The issues of the candidacy in the governorship race for the opposition parties in the state appears to have been caught up in the web of legal controversies. It was the case for the main opposition party, but now it is the Accord party that is in the picture.
These grave anomalies and brazen overt support and bias of the state ESCO of our great party.
A former APC governorship aspirant in Rivers State, Dumo Lulu Briggs, on the fallout of the crisis that rocked his erstwhile party in 2018.
Breach of Section 87 of the Electoral Act 2010 as amended and Article 24 of the APC Constitution. 2. The leadership of the party in the state has overtly shown preference and support for one of the aspirants to the exclusion of all others, even before the governorship primary. 3. The leadership of the party in Rivers State has refused to accord aspirants a level playing field ahead of the primary because I have no access to neither the delegates list nor the party guidelines.
Touted by some as the leading contender against the ruling party in the state after the APC failed to make the cut, Mr. Lulu Briggs faced a similar fate in 1999, 2003, 2007, and 2015 with his unsuccessful bid to become the flag bearer of the PDP. He moved to the Accord party in December 2018. But the matter of who is the authentic candidate of the Accord party rages in Court 2 of the Federal High Court in Port Harcourt. The presiding judge held that since the candidate of the party did not participate in the October 4, 2018 primary, he was illegally used to substitute Precious Barido, who reportedly won the primaries.
Someone who never participated in the primaries of the Accord party, but went by state, maybe because of affluence, to acquire or purported to acquire the candidature, even when the party conducted primaries and had a candidate.
Our fear from the beginning was that we would not get justice before this court. That has always been raised but however, we have an opportunity of appealing against the judgment since we were dissatisfied with it.
For the plaintiff, this is victory for the rule of law.
This is to stop impunity and imposition of candidates on political parties. To God be the glory. The victory belongs to God and Rivers people. I urge my supporters to prepare for the election.
As the days count down to the governorship election in Rivers State, it will be interesting for many to see the expected judicial challenges and how events eventually pan out. Emmanuel Irene, Channels Television News.
Let me tell you, those of you who have not known me, go home and sleep. Nobody born of a woman can stop us from victory. Nobody. It doesn't matter the gunboats, it doesn't matter the personnel they come with the weapons, but he who has all the weapons is with us. He who fights for us is always with us. So don't be shaken, don't be worried. They came with all they could come with. God said, no, it's not possible. Rivers State is God's own state. We have dedicated this state to God. And I want to say again, this state is a Christian state. I owe no apologies to anybody. Anybody can go and plan against me. You are not planning against me, I plan against God.
Well, to at least shed some light on what's going on, we have Ritchard Wokocha, who is an associate professor of law with Rivers State University. Prof, thank you for joining us again today. Well, many just keep wondering, what is happening again this time in Rivers concerning this particular judgment? Because now that the courts have said the Accord party and INEC should actually substitute the name of Lulu Briggs with that of Baribo, Sir Precious Baribo.
Yes.
Did you see this coming? Because, I mean, some lawyers were saying that they had always maintained that they were not going to get justice from the courts.
Oh, it was long of the way coming because Section 184 of the Constitution, the fourth alteration, introduced a revolutionary amendment, and this was therefore coming. If you look at subsection 14C, it leaves room for all of these actions. For the first time, it made it possible for a political party to intervene in what usually and traditionally used to be an intra-party affair and to take advantage of it. And so that's what is playing out here now.
But, you know, looking through what Mr. Briggs has said, part of what he was saying there is that he didn't substitute Nelson Ameye. He substituted actually Nelson Ameye and not Sir Precious Baribo. But did it appear as though the court turned the deaf ear to what he actually says?
Well, the tragedy here is that the Electoral Act, Section 33, which talks about subscription, now says there shall be no substitution. It gives only two conditions by which things can change or a candidate can change. First one is found in Section 35, where it talks of withdrawal, where a candidate withdraws, an otherwise nominated candidate withdraws, or Section 36, where such candidate dies. So it's no longer possible by virtue of these provisions, it's no longer possible to substitute persons with or without reason, but the only thing that can be done now is to ask a person to step down before you can substitute. And the evidence of stepping down, which is a letter by him resigning, withdrawing from the race, has to be submitted to INEC for that substitution to be valid. And so there was no evidence of this according to the court. There was no letter indicating that the candidate who emerged from the primaries resigned before he was brought forward by the party as a substitution.
Yeah, because part of what he was saying is that in the first place, he said, look, that Sir Precious Baribo never even bought the expression of interest form to contest for governorship. And secondly, he was the chairman and not a candidate. So he doesn't know how all of a sudden he claims that he was a person, because the person he had dealings with was Nelson Ameye.
No, that's another matter. That raises a second angle to it. The first thing to understand is that his candidature became affected once there is no evidence of resignation by whoever was the candidate nominated. It means his own candidature had become affected. Now, what you can quarrel about is the emergence of the name that the court now returned as the proper candidate. That can now also be contested if that was not the name that contested the election. But that can be raised by anybody who goes to court to raise that issue, or any relevant party who goes to court to raise that issue. But it does not in any way affect the validity of his own nomination in place of the name he says is the proper name that emerged from the primaries before he moved on. The only thing he can say that will validly alter his circumstances is that the gentleman resigned. And I have here the evidence of his resignation, and we tendered it in court, and the court did not use it, or the court refused to follow it. That's the only thing that he can say that will affect his candidature.
Oh, who actually resigned? Sir Baribo resigned or Nelson Ameye resigned?
Whether it's Baribo or Nelson, what he needs to prove for his case to be different is that whoever he says is the person who won the primaries resigned before he came in. Now, if there is no evidence of the person resigning or dying, his candidature is invalidated by the Electoral Act. The subsection 33, which says there shall be no substitution, except on these two grounds that are produced in subsection 35 and 36.
But Prof, if you say, okay, what if there was no evidence of him resigning and another person was actually occupying that seat, and that there wasn't any record of any fracas between the person who is said to have resigned and the person who is occupying the seat? How then do you then say that there was any dispute amongst them?
Now, because the language of the law is negative, there shall not be, or there shall be no substitution. You have a situation where the action of his substituting that other person, whomever it is invalid, unless the precondition is met, which is a production of the letter of resignation or proof that the person died. Because those are the two conditions on which the law allows substitution under the Electoral Act 2010 as amended. Those are the two conditions that must be met, one of which must be met before a substitution which the law says should not take place can be validated. So for purposes of his validity, what he needs to show is that whoever was there, whether Nelson or Precious, resigned, and that he tendered that letter of resignation in court, and the court refused to follow it. Otherwise, he has no case.